and welcome to the second session of Federal Trials and Great Debates in U.S. History, Judicial Independence. My name is Christine Lamberson. I'm the Director of the History Office at the Federal Judicial Center. This series is put on by the FJC and the American Bar Association. I want to thank my colleagues at the FJC, including Director John Cook and Deputy Director Clara Altman, as well as the information technology staff, especially Christopher Murray, for making the series possible. The program is in collaboration with the American Bar Association Division for Public Education. Kathy Hawk and her colleagues at the ABA have put much preparation to make this program possible. You will hear more from Kathy in other sessions. If you have not yet watched it, the first session of this series introduced the program and provided a historical overview of judicial independence. If you have watched that session, you have already met our guest for today's session, Professor Tara Leigh Grove. In this video, Professor Grove will be discussing some key historical cases that have shaped the federal courts and helped answer questions related to judicial independence and the separation of powers. Each of these cases is also part of a Federal Judicial Center series on the website, including written materials about cases that shape the federal courts. You can find those at fjc.gov. Thank you for joining us, and welcome, Professor Grove.
Thank you so much. So the Supreme Court is in charge of the Constitution, right? That's what most of us think. The Supreme Court is the leader in telling us what the Constitution means. If there's any question, we just wait until June of some year and they will tell us. What I want to suggest is that that hasn't always been the assumption in American society. Actually, the Supreme Court's current role was built over time and through some pretty tumultuous situations. And I'm going to tell that story by talking about three cases from very different periods of time. First, Marbury versus Madison in 1803. The country was just barely over a decade old, and the court's main job was to establish itself as having really anything to do at all in our constitutional system, much less be a leader. And we'll see that that's exactly what then Chief Justice Marshall did. Then I'm going to talk about Ex parte Cardle in 1869. This is the post-Civil War Reconstruction era. And things were pretty dicey for the US Supreme Court then. And people certainly didn't assume that this court was going to be in charge of constitutional law. And finally, I'm going to end with City of Burney versus Flores from 1997. This decision was issued at a time when the Supreme Court was a very powerful institution. And you'll see that the Supreme Court itself treated itself as quite a powerful institution and as the leading expositor of federal constitutional law. And one of the things I want you to ask yourselves as you listen to these three different stories is, should the Supreme Court have that role in our society? All right, so let's start off with Marbury versus Madison in 1803. This is really a doozy of a case when you dig into the facts. I often tell my students that Lin-Manuel Miranda should make his next production about the facts of Marbury versus Madison because it's really juicy in terms of what was going on with the players there. All right, so this is a case that I think a lot of people have heard of, and I'm going to try to give you a little more information about what was going on in the case and at the time. So William Marbury sued then Secretary of State James Madison for a commission. Now, this was basically a commission to do a job as the Justice of the Peace in Washington, D.C. So a commission is like a contract to say, hey, I get to do this job. And Madison didn't give him the commission. Well, that seems pretty simple. But how did all this come about? Well, after Thomas Jefferson won the presidency in 1800, but before he actually became president, the outgoing Federalist Party under then President John Adams did a lot of pretty extraordinary things when it comes to the federal judiciary. The Federalist Party decided it was going to expand the federal judiciary, create 16 new Article III judgeships. At this time, the federal judiciary consisted of a couple dozen federal court judges. They were going to dramatically expand by a third or one half the size of the federal judiciary, or maybe even by doubling the federal judiciary. This Federalist Party also decided that they would cut the future size of the Supreme Court to 5 members so that Thomas Jefferson could not appoint a Supreme Court justice. And they did all this on the eve of the Jefferson presidency. Oh, and one last thing John Adams did. He decided to have his then Secretary of State, John Marshall, become Chief Justice of the United States. And in a law that didn't get as much attention, the Federalist Party also created all these justices of the peace. And that was the law that William Marbury wanted to enforce. Okay, so, well, if John Adams was the one who actually appointed William Marbury, then what does James Madison have to do with this? Well, it turns out that James Madison wasn't the one who was supposed to deliver the commission. The commission was supposed to be delivered by John Adams' Secretary of State, who, by the way, as you probably just got from what I told you, was John Marshall. So John Marshall was supposed to deliver the commission, just failed to do it. He claimed later, I just didn't get to it, didn't have time, didn't think it would matter. And then Secretary of State James Madison came on, and as you can imagine, Thomas Jefferson wasn't thrilled with having all these extra Federalists around. He said, no, don't deliver these commissions. They didn't get to it. We're not going to do their job for them. And that's what led to the lawsuit. Now, to make matters even crazier, Secretary of State James Madison didn't show up at the US Supreme Court to explain himself because he said, look, the Supreme Court has absolutely no business telling me what I can and can't do. So he wasn't there. And William Marbury also brought what is called an original lawsuit in the Supreme Court. Now, in the world of the federal judiciary, we distinguish between original cases, that is, cases you bring in a court to have a trial, and then appellate cases where you try to challenge that decision from the lower court in a higher court. And Marbury brought this suit in the Supreme Court's original jurisdiction, and there was actually a trial at the US Supreme Court. So just imagine this. Marbury is sitting there with his counsel, a man named Charles Lee, not to be confused with the Charles Lee from Hamilton, for all of you Hamilton fans, different guy. So Marbury's there, represented by Charles Lee. Madison hasn't bothered to show up. The Attorney General for Thomas Jefferson is there, and he was also one of the people who failed to deliver the commissions, and at least some sources say might have destroyed the commissions. Marbury is trying to prove that he has a commission, which no longer exists. And the person who is most likely to know whether Marbury had a commission is the guy presiding over the trial, John Marshall. But John Marshall can't get down from the bench and start testifying, and so they have to use other means to prove that there really was a commission. Now, many of you are probably thinking, why was John Marshall ruling in this case at all? That's a good question. The recusal policies, that is the policies that say that a judge should step down, weren't as big back then. And so John Marshall not only decided to preside over the case, but actually issued the opinion in the case, ruling for the Supreme Court. So there's all this craziness at the trial. And then the Supreme Court issues its decision. And this is pretty extraordinary too. And I'm going to tell you a little bit about the decision, and then I'm going to give you some more background as to what was going on. Chief Justice Marshall starts off the opinion in Marbury versus Madison saying, William Marbury had a commission and he deserves to have his job. And in fact, the job of courts is to enforce legal rights, like William Marbury's right to his job. But then the court goes on to say, we're not going to do that. We don't have jurisdiction to issue this ruling. Now, before I explain that ruling, I want to say a little bit more about what was going on at that time. I've already told you that before Thomas Jefferson took office, the outgoing Federalist Party expanded the federal judiciary and just did a whole bunch of last-minute reforms. And just imagine if right before, say, Barack Obama had taken office, outgoing President George W. Bush had said, hey, I'm going to double the size of the federal judiciary. Or right before President Biden took office, President Trump said, I'm going to double the size of the federal judiciary. You can imagine the incoming party would not be thrilled. Well, the Jeffersonians were not thrilled at all. And one of the first things that they did was repeal the law that established those judgeships. The 1802 Act said, hey, all you guys who just got appointed to Article 3 positions by John Adams, you're out of a job. Now, for those of you who have looked at the constitutional text, the Constitution says that federal judges have their jobs during good behavior and get to have their salaries not reduced ever. And most people today believe that means life tenure. A lot of people back then argued that means life tenure. But the Jeffersonians said, well, we're not firing the judges. We're just abolishing their positions. And for the judges themselves, it meant the same thing. Okay, so that was one thing the Jeffersonians did. Another thing the Jeffersonians did was actually delay the Supreme Court's ability to hear cases. Now, the trial that I just told you about in Marbury versus Madison took place in 1801. And if you looked at history books, Marbury versus Madison, the decision was in 1803. So what were they doing in the interim? The Jeffersonian Congress came in and actually abolished the Supreme Court sitting for 1802. The statute said the Supreme Court couldn't hear any cases or decide any cases during that time. Now think about that. It's 2021 right now. It's the equivalent of Congress coming in and saying the US Supreme Court cannot speak on anything until 2023. We're just saying nothing in 2022, at least at the Supreme Court level. That is what the Jeffersonians did. They did a third thing too. They started initiating impeachment proceedings against Federalist judges that they thought were going overboard. So when Chief Justice John Marshall was writing the opinion in Marbury versus Madison in 1803, he knew this. The Jeffersonians had fired Article 3 judges, delayed the term of the US Supreme Court, and were starting impeachment proceedings against Federalist judges they don't like. And John Marshall had to assume that he would be one of those judges eventually. John Marshall had no reason to believe that the Jeffersonians would obey any decision that the US Supreme Court issued against them. Secretary of State James Madison, as I told you, didn't even show up at the trial to signal, hey, we don't think you guys have any business here. So Chief Justice John Marshall thought of a way out. How do I issue a decision that kind of defers to these Jeffersonians without completely obliterating the Supreme Court's authority? And that is the decision he set out to issue in Marbury versus Madison. So after all this talk about how Marbury should get his commission, then Chief Justice John Marshall says, but we don't have jurisdiction to issue it. And what he says is, the Judiciary Act of 1789 that gives us jurisdiction, that is the power to decide this case, did give us the power to have original jurisdiction here, that is, hold the trial that we just held. But the Constitution says that we don't have that power. The Constitution says we can hold trials, that is, do original jurisdiction, just in a certain set of cases. And this one doesn't fall into that category. And when there's a fight between the Constitution and a federal statute, the Constitution wins. This is the doctrine of judicial review. Not only that the Constitution wins, but also that the federal courts get to say that when they're deciding a case or controversy. And a good part of the opinion in Marbury versus Madison goes on to try to justify this. Chief Justice John Marshall says, well, Article 3 says that we hear cases arising under the Constitution. Article 6 of the Constitution, the Supremacy Clause, says that the Constitution is the supreme law of the land. Other provisions speak to the courts. They say that people can't be tried for treason unless there are two witnesses. There can't be bills of attainder, that is, laws that are criminal sanctions against individuals, and we have to enforce those too. Now, I think for modern ears, one might think, Why are you talking so much, guy? Judicial review's a thing. We know it. You don't need to go on for pages and pages and pages. At the time, it was far less clear that judges would have that power to say that a federal statute was unconstitutional and have other folks actually obey them. But note what Chief Justice Marshall did here. In declaring a part of the Judiciary Act of 1789 unconstitutional, Chief Justice Marshall announced that the Supreme Court could exercise the power of judicial review without President Jefferson or Secretary of State James Madison having to do anything at all. So no one could challenge his decision. Hey, we don't have jurisdiction, can't do anything here. And yet Marbury versus Madison proclaimed the power of judicial review. What I also want to underscore is what Marbury versus Madison did not say, even though some scholars today think it may have hinted in this direction. Marbury versus Madison did not say that the federal judiciary was the only entity that should be in charge of enforcing the Constitution. At the time, it was very well understood that members of Congress should vote against laws that they viewed as unconstitutional. The president should veto laws that he viewed as unconstitutional, and maybe not even enforce laws that he viewed as unconstitutional, or pardon individuals who were convicted under laws that the president believed were unconstitutional. And there was also an understanding that the public had a role in enforcing the Constitution. One of the things that I underscore for my students, and for my own children too, is that the first 3 words of the US Constitution are "we the people." The Constitution doesn't start off talking about Congress or the president or the Supreme Court. The Constitution starts off with "we the people." And at the time, it was understood that if we the people thought that individuals were violating the Constitution, they could demonstrate that unhappiness through protests. They could demonstrate that unhappiness through petitions to the government, and they could demonstrate that unhappiness through the electoral process. They could, as I say to my students, vote the bums out if they thought those bums were violating the Constitution. What Chief Justice Marshall was saying in Marbury versus Madison is, hey, we have a role too. We, the judiciary, can, just like the legislature, just like the president, and just like the people, also help enforce the Constitution. Not that the court was in charge of the Constitution, but that the court was part of this enforcement process. Chief Justice Marshall was saying, hey, we've got skin in the game too. That's a far cry from what you hear from the Supreme Court today. Okay, so that was 1803. The goal was to kind of build up the Supreme Court's power to maybe be used later on. Now let's fast forward to 1869. This was another pretty tumultuous period for the federal judiciary in lots of different ways. In the 1860s, of course, the nation was embroiled in civil war. And then there were Reconstruction efforts after that. The South had lost the war, and the North was trying to reconstruct the South, expand suffrage to African Americans, and try to clean things up after a really tumultuous moment. And the Supreme Court was caught in the midst of all of this in a couple of different ways. Now, one thing that people often don't know about the 1860s is that was a time when Congress actually sought to empower the federal courts quite a bit. So after the Civil War, the US Congress was largely controlled by Reconstruction Republicans. So most of the southern states were not allowed to send representatives to Congress yet, because after all, they had been engaging in insurrection against the US government, and they needed to be reconstructed before they could rejoin the Union. So it was a very one-sided party system in Congress that was trying to support Reconstruction. And one thing the Reconstruction Republicans did not trust was the state court system across the South. And they had every reason not to trust it. Already, even in the 1860s, even after the Civil War, Some governments were trying to make it difficult for newly freed slaves to exercise the rights to which they were constitutionally entitled. And not only both state courts and state law enforcement officials were not enforcing laws to protect newly freed slaves or the people who supported them. There were a lot of concerns about whether the state justice system in the South would protect African Americans. And so Congress set about expanding federal jurisdiction. Let's give people, particularly people trying to support electoral and other rights for African Americans, let's give them a place to go to the federal judiciary to protect those rights. So in the late 1860s, Congress expanded federal jurisdiction across the board, but particularly in cases called habeas corpus cases. That is, if someone was imprisoned by a government official in a state, that person could go to a federal court and ask for assistance. Habeas corpus is a way of doing that when you're detained. All right, so that was the setup. And Congress, in the midst of all this, also gave people a new right to appeal to the US Supreme Court in these habeas corpus cases. All of this being designed to protect and promote the Reconstruction efforts in the South. Well, then along came a guy named William McCardle. William McCardle was not a newly freed slave. He was not a supporter either. In fact, he was precisely the opposite of everything Congress had been trying to protect. William McCardle had been a soldier in the Confederacy during the Civil War, and he wasn't just a soldier, he was a militant in favor of the Confederacy. He had advocated secession long before the states actually seceded from the Union. So he was a strong supporter of the Confederacy, and after the war ended, became an editor of the Vicksburg Times in Mississippi, and did everything he could to thwart Reconstruction efforts. So he opposed Reconstruction, he opposed Black suffrage, and he wrote things that were, let's just say, not ready for prime time to repeat today. But I'll say a little bit about what he wrote. In 1867, Congress was trying to get, in the late 1860s, including 1867 in Mississippi, Congress was trying to get the reconstructed states to pass new state constitutions that granted African American, I should say males at the time, this was before women's suffrage had been expanded, but grant African American males the right to vote alongside, so that African Americans and Caucasians had the same rights. William McCardle not only wrote editorials in the Vicksburg Times opposing this, but actually he referred to those who voted in favor of the new Constitution as, quote, scoundrels and sneaks. These were some of the more calm terms that he used. And get this, he threatened to publish the names of anyone who voted for the state constitution that would accept African American suffrage. He threatened to publish the names of individuals who exercised their right to vote in favor of a new democratic system. Well, the Reconstruction Congress and the military who was controlling the southern states at the time did not particularly like William McCardle, and they put him in jail. So he was actually jailed by the United States military. And that's strange to modern ears, because what William McCardle was actually doing was speaking, right? He was exercising his free speech rights, doing it in a way that many today would find distasteful, many then found distasteful, but that's what he was doing. Well, at the time, it was not at all clear that you had a First Amendment right to do what William McCardle was doing. Most of our free speech doctrine came much, much later. So the military had no reason to think that they were violating the First Amendment by arresting the guy. And then William McCardle did something that the Reconstruction Congress just could not believe. He filed a federal habeas corpus petition using those laws that they had just passed to protect African Americans and supporters of Reconstruction. And the Congress thought, are you serious? This guy? So William McCardle took his case to the federal district court. He lost there, and then he took his case up to the US Supreme Court. And he was not only challenging his detention, he was challenging the constitutionality of Reconstruction. He said, Congress does not have the power to say that a bunch of states in the Union are subject to military government. So Ex parte Cardle was not just a challenge to this one detention. It was a challenge to the entire scheme that Congress had created in the post-Civil War era to reform the South and create a new system of government. So this case goes up to the US Supreme Court under, as I said, the law that Congress had just passed. And the Reconstruction Republicans were horrified. And so while the case was pending in the US Supreme Court, Congress passed a law taking away the Supreme Court's jurisdiction over these appeals. So this was after the case was already at the US Supreme Court, but before the court issued its decision, Congress took away its jurisdiction. Now, there are a lot of things one can say about that. As I've described, William McCardle was not exactly a nice guy. But the principle that Congress can take away the jurisdiction of the US Supreme Court in a case that's actually pending before it right at that moment is something that has haunted scholars ever since. Because Congress might not just take away the Supreme Court's jurisdiction in a case involving William McCardle. It might take away the Supreme Court's jurisdiction in cases involving a slew of civil rights, whether we're talking about gun rights or the right to terminate a pregnancy or voting rights. But in Ex parte Cardle, the Supreme Court said, we are not going to challenge Congress's authority. Article 3 of the US Constitution says that we have appellate jurisdiction, quote, subject to such regulations and such exceptions as the Congress shall make, end quote. And that gives Congress the power to do what it's doing here. Now, I will say, without getting too deep in the weeds of jurisdiction, it's not clear just how far the Supreme Court went in Ex parte Cardle. One can read the case to say Congress can take away a court's jurisdiction whenever it wants to, or Congress can read or one can read the case to say, no, Congress can only do that if there's some other way to get to the US Supreme Court, because at the time, there was still another way for a case like that of William McCardle to reach the Supreme Court. So we don't know exactly how far the Supreme Court went there. But note, as in 1803, the Supreme Court was not inclined to challenge Congress's authority. The Supreme Court was not inclined to say, hey, Congress, you can't pass this law taking away our jurisdiction. The Supreme Court said, we're accepting your power, Congress. And we are not in charge of deciding all constitutional claims. And in part because of that decision, the Supreme Court never did rule explicitly on the validity one way or the other of Reconstruction. So that's 1803 and 1869. And these were pretty tumultuous periods in American society and pretty tumultuous periods for the US Supreme Court. But things started to change for the US Supreme Court after that. Starting in the early 20th century, mid-20th century, the Supreme Court began to be more and more accepted, not totally, but especially by the mid-20th century. More people were accepting the US Supreme Court as being in charge of interpreting constitutional law. And that seemed to be the view by 1997, when we get to City of Burney versus Flores. Now, City of Burney versus Flores is a case that I think is well known to the world of constitutional law scholars. It's probably less well known outside of constitutional law scholars. So let me tell you a little bit about it. City of Burney versus Flores in 1997 came out of some fights over the court's role in enforcing religious liberty. So in 1963, the Supreme Court, this was during the Warren Court era, the Supreme Court issued a decision saying that when a law passed by the government infringes on religious liberty, we're going to take a close look at that. were nervous about these types of laws that make it harder for people from different religions. That case involved a Seventh-day Adventist who lost her job because she wouldn't work on Saturdays. The Supreme Court said, okay, we're going to scrutinize these kinds of laws. Then in 1990, the Supreme Court took a very different turn towards religious liberty. And this was in a case called Employment Division versus Smith, a decision written by Justice Scalia. The Supreme Court said, okay, if Congress or a state government actually attacks a person on the basis of his or her religious liberty, we'll scrutinize that. But if a government just passes a law that applies to pretty much everybody, and it's not targeted at any one religion, we're not really going to scrutinize that. We're going to say that's okay, because there are lots of different laws that might infringe on religion. In this case, it was an employment law that had made it hard for a couple of people who had used the drug peyote to get unemployment insurance. Peyote is a sacramental drug for Native Americans. And Justice Scalia said, look, it's true in this case, it has the law saying you don't get unemployment insurance if you were fired for cause. That has some adverse effects in this one instance, but really it's a general law. It was not targeted at any religion. It's fine. And that was the state of things in 1990, and actually still is the state of things to this day under the Free Exercise Clause, the First Amendment, although there's been a lot of movement in this area as well. Well, Congress was not pleased by this. And it was actually an extraordinary political moment in Congress where lots of different religious groups came together, majority religions, minority religions came together, Democrats and Republicans came together and passed the Religious Freedom Restoration Act of 1993. Now, the Religious Freedom Restoration Act was designed to overrule Smith. And that's actually what Congress said it was trying to do. It said, hey, we think you guys are wrong to say that neutral laws of general applicability, these laws that apply to everybody, are just okay, even if they harm religion. That's just wrong. And so Congress said, from here on out, when a law substantially interferes with somebody's exercise of his or her religion, courts scrutinize those laws, apply a level of scrutiny that in the law world we often call strict scrutiny. Make sure the government has a really strong interest and make sure the law is carefully tailored to that interest. Terms that we use the terms compelling interest and narrow and least restrictive means in the law world. This law passed the House of Representatives unanimously. It passed the Senate 97-3 and was signed into law by President Clinton. Bipartisan, very, very popular. And the validity of that law, at least as applied to state and local governments, came to the court in City of Bernie versus Flores. So in that case, a local church wanted to make a couple of changes to its building. And basically it was in a historical site and the city said, nah, no can do. You're in a historical area. We don't want these changes to your building. And the local church filed suit. And the local church said, hey, RFRA, the Religious Freedom Restoration Act says you can't do this. You have to show that you have a compelling interest to interfere with our religious liberty rights, and that denying this permit is the least restrictive means. And the government responded, well, it's actually not constitutional for Congress to tell us that, to tell us how we do things down in our states and localities. And an underlying thing in all of this was the fact that Congress, in the Religious Freedom Restoration Act, had effectively tried to overrule the Supreme Court's decision in Employment Division versus Smith. While writing for the court, Justice Kennedy said that the Religious Freedom Restoration Act is unconstitutional as applied to states and localities. Still applies to the federal government to this day. Unconstitutional as applied to states and localities. So a lot of the opinion is about how Congress shouldn't interfere with how states and localities do their business. But a huge part of the decision was also about the relationship between the Supreme Court and Congress. And Justice Kennedy said, look, we are in charge of the US Constitution. In Employment Division versus Smith, we defined the meaning of the Free Exercise Clause. You may not like it. Clearly you don't. But that is our job. And it is not your job to tell us we were wrong. We, the Supreme Court, are in charge of the US Constitution, Congress, and you can't come back and try to redefine the Free Exercise Clause or any other part of the US Constitution. That's not your job. Now note, this is a huge, huge jump from Marbury versus Madison, where Chief Justice Marshall was saying, hey, let us enforce the Constitution too. We're here. We're not going to do very much yet, but we're here. Or 1869, where Congress actually stopped the Supreme Court from issuing a constitutional ruling, and the justices said, yep, you can do that, Congress. We're not going to say anything about these Reconstruction laws. Justice Kennedy, on behalf of a supermajority of the Supreme Court, said, Congress, you don't get to go and define religious freedom. That's up to us. Now, these decisions have lots and lots of implications for various areas of doctrine. And in fact, some of the decisions that I've just been talking about, like City of Boerne versus Flores and Employment Division versus Smith, are in lots of modern doctrinal debates over what is the Supreme Court going to do in the world of religious liberty. But what I want you to think about is, should the Supreme Court have this exclusive and supreme role in interpreting the federal Constitution? Was it really wrong for Congress to come in and say, hey, we don't think you guys are enforcing religious freedom enough, so we'd actually like to see it enforced more? And this isn't just about religious freedom. In the 1950s and 60s, the Supreme Court was actually hesitant to enforce civil rights. And Congress came in with the Civil Rights Act of 1964 and the Voting Rights Act of 1965, a Voting Rights Act that was repassed during several different administrations, Republican and Democratic alike. And the Voting Rights Act is a statute that does more than Supreme Court jurisprudence had done at the time. And a question is, well, doesn't Congress have that kind of role too? Maybe not to contract rights that have been recognized by the US Supreme Court, but to expand rights that have not yet been recognized or not fully protected by the courts. I think these are extremely hard questions, and they're questions that our society is facing right now. But I do want to suggest, at least as a historical matter, it is not at all obvious that the US Supreme Court should be exclusively in charge of the US Constitution.
Thank you, Professor Grove, for that wonderful presentation. I hope all of you watching enjoyed it. Please join us for our next two sessions. Session 3 is a panel with 2 federal judges speaking about judicial independence and their experiences in the federal judiciary. Finally, our last session will discuss primary sources related to Ex parte Cardle and our series from the FJC on cases that shape the federal courts. Please join us then.